I never thought my wheelchair ramp would become a battlefield. But that's exactly what happened when Patricia Henderson, president of the Meadowbrook Estates Homeowners Association in suburban Atlanta, Georgia, decided that my basic accessibility needs violated her precious community aesthetic guidelines. My name is David Carmichael, and I'm a 42-year-old software engineer who moved to Meadowbrook Estates 3 years ago with my wife, Jennifer, and our 2 kids, Emma and Lucas. Life was pretty normal until last year when a drunk driver ran a red light on Peachtree Street and changed everything. The accident left me with severe spinal injuries, and after months of grueling physical therapy at Shepherd Center, I came home in a wheelchair. The doctors said I might regain some mobility eventually, but for now, this was my reality. Our house was a beautiful 2-story colonial with a front porch that had 4 steps leading up to the main entrance. Before the accident, those steps were just steps. After the accident, they became an insurmountable barrier. I couldn't get into my own home without Jennifer, and sometimes a neighbor helping to lift me and my wheelchair up those steps, which was not only exhausting for everyone involved but also incredibly dangerous. I needed a wheelchair ramp, and I needed it fast. Jennifer contacted 3 different contractors in early March to get quotes for a wheelchair ramp. We wanted something professional, safe, and as aesthetically pleasing as possible. The contractor we ultimately chose, a guy named Marcus who ran a company called Accessible Homes Atlanta, proposed a modular aluminum ramp with handrails that would run along the right side of our front steps. It would have a gentle slope meeting ADA guidelines, non-slip surfaces, and would be painted to match our house's cream and gray color scheme. Marcus assured us it would look clean and professional, not like some temporary construction. The quote came in at $3,800, which wasn't cheap, but this was my independence we were talking about. I couldn't stand the idea of being carried into my own house, like a piece of furniture every single day. We signed the contract on March 15th, and Marcus said he could start installation the following week. That's when Jennifer reminded me about the HOA. In all the chaos of my recovery and trying to adapt to my new reality, I had completely forgotten that Meadowbrook Estates had one of those homeowners associations that regulated everything from fence heights to mailbox styles. Jennifer pulled out the thick binder of HOA rules we'd received when we bought the house, and sure enough, there was a section about exterior modifications requiring approval. I drafted a formal request to the HOA the next day. I explained my situation, attached a letter from my doctor confirming my need for wheelchair accessibility, included the contractor's plans and specifications for the ramp, and even added some photos showing what the finished product would look like. I thought I was being thorough and responsible. I submitted the request to Patricia Henderson via email and through the HOA's online portal on March 17th. The response came faster than I expected. 2 days later, on March 19th, my phone rang at 8 in the morning. The caller ID showed a number I didn't recognize, but I answered anyway. "Is this David Carmichael?" a sharp voice asked without preamble. "Yes, this is David. Who's calling?" "This is Patricia Henderson, president of the Meadowbrook Estates HOA board." "I'm calling about your ramp request." Something about her tone immediately put me on edge. There was no warmth, no acknowledgement of my situation, just cold business. "Oh, great," I said, trying to stay positive. "I hope you received all the documentation. I tried to include everything you might need to review." "Mr. Carmichael, I did review your request, and I'm afraid the board cannot approve this installation. The proposed ramp violates Section 7.3 of our community guidelines regarding front-facing structures and Section 12.1 regarding aesthetic uniformity." I felt my stomach drop. "I'm sorry, what? Patricia, I need this ramp to get into my house. I'm in a wheelchair." I understand that you have medical challenges, Mr. Carmichael, but the HOA guidelines exist to maintain property values for all residents. Your proposed ramp would be visible from the street and would set a precedent for other exterior modifications that could compromise our community's appearance. I couldn't believe what I was hearing. Are you seriously denying me the ability to access my own home? I'm denying an exterior modification that doesn't meet our architectural standards, Patricia said, her voice maddeningly calm. Have you considered a rear entrance ramp? That would be much less visible and might be approvable. Patricia, our rear entrance is through the garage, which is already accessible. But I can't park in my garage every single time I need to enter or exit my house. Sometimes I take medical transport. Sometimes friends visit. I need to be able to use my front door like every other person in this neighborhood. Then you'll need to submit a revised proposal that meets our guidelines. The decision is final for this current design. You'll receive a formal written denial in the mail within 5 business days. She hung up before I could respond. I sat there in my wheelchair in our kitchen, staring at my phone in disbelief. Jennifer walked in with a basket of laundry and immediately saw my face. What happened? She asked, setting down the basket. I told her about the phone call, and I watched her expression shift from confusion to anger to something that looked like despair. We had been through so much already, and now this felt like yet another obstacle in an endless series of obstacles. They can't do that, Jennifer said firmly. There have to be laws protecting people with disabilities. This is discrimination. I don't know, I admitted. I mean, we signed those HOA documents when we bought the house. Maybe they actually have the right to do this. Jennifer grabbed her laptop and started searching. Within minutes, she had found information about the Fair Housing Act and its provisions regarding reasonable accommodations for people with disabilities. She read aloud passages about how HOAs are generally required to make exceptions to their rules, when those rules prevent a disabled person from fully using and enjoying their home. David, they're legally wrong, she said, showing me the screen. The Fair Housing Act should override their stupid aesthetic guidelines. You need to fight this. I felt overwhelmed. Fighting the HOA sounded exhausting, and I was already so tired from everything else. But Jennifer was right. This wasn't just about convenience or comfort. This was about my basic rights. The formal denial letter arrived on March 23rd, exactly as Patricia had promised. It was 2 pages of bureaucratic language essentially saying that while the board sympathized with my situation, they could not compromise the community's standards. The letter suggested I consider alternative solutions such as a rear ramp, a portable ramp that could be set up and taken down as needed, or interior modifications to make our garage entrance more convenient. Every suggestion was ridiculous. A portable ramp would still need to be stored somewhere and would be a hassle to set up constantly. The garage entrance suggestion ignored the entire point. I needed normal access to my front door. I called Marcus the contractor and explained the situation. He wasn't surprised. Man, I deal with HOAs all the time, he said with a heavy sigh. Some of them are reasonable, but some of them act like wheelchair ramps are going to cause property values to crash. It's nonsense, and honestly, it's probably illegal. You should talk to a lawyer. That word, lawyer, made everything feel more serious and more real. I had never sued anyone in my life. I didn't want to be that person who gets into legal battles with their neighbors. But what choice did I have? Jennifer found a disability rights attorney through a recommendation from someone at the Shepherd Center. His name was Robert Chen, and his law firm, Chen and Associates, was located in downtown Atlanta near Centennial Olympic Park. His assistant scheduled a consultation for March 27th. Robert Chen's office was on the 14th floor of a glass building with a spectacular view of the Atlanta skyline. The office itself was immaculately accessible, with wide doorways, lowered reception counters, and a spacious conference room where Robert met with us. He was a man in his early 50s with graying hair and kind eyes behind wire-rimmed glasses. He rolled up his sleeves and got straight to business after brief introductions. "Tell me everything," Robert said, pulling out a legal pad. I walked him through the entire timeline, from the accident to the ramp proposal to Patricia's phone call and the denial letter. Jennifer handed him copies of all our documentation, including my medical records, the contractor's plans, and the HOA's denial letter. Robert read through everything carefully, occasionally making notes. When he finished, he looked up at us with an expression that was both sympathetic and determined. "Okay, here's the situation," Robert began. "The Fair Housing Act is federal law, and it prohibits discrimination based on disability in housing. That includes not just the sale and rental of housing, but also the rules and regulations that govern communities like yours. The law requires housing providers, including HOAs, to make reasonable accommodations for people with disabilities. So they have to let me build the ramp?" I asked. "In most cases, yes. A wheelchair ramp for someone who actually needs a wheelchair is about as reasonable an accommodation as you can get. The HOA can't just deny it because they don't like how it looks. However, they do have the right to request that you meet reasonable requirements regarding the design and construction, as long as those requirements don't make the accommodation impossible or ineffective." "So what do we do?" Jennifer asked. "First, I'm going to send a letter to your HOA explaining that their denial violates the Fair Housing Act and demanding that they approve your ramp installation. This letter will give them a chance to reconsider and do the right thing without litigation. Sometimes that's all it takes. Some HOAs just don't understand the law, and once it's explained to them by an attorney, they back down." "And if they don't back down?" I asked, though I already knew the answer. "Then we file a complaint with the Department of Housing and Urban Development, and if necessary, we file a lawsuit in federal court. Based on what you've told me and what I see in these documents, you have a strong case. The HOA's denial appears to be a clear violation of your rights under the Fair Housing Act." Robert explained his fee structure. He typically worked on a contingency basis for Fair Housing Act cases, meaning he would take a percentage of any settlement or award we won, and we wouldn't have to pay him upfront. He also explained that if we prevailed, we could recover attorneys' fees from the HOA, which was a provision built into the Fair Housing Act to encourage people to enforce their rights. We hired Robert that day. He drafted a demand letter and sent it to Patricia Henderson and the Meadowbrook Estates HOA board on March 30th. The letter was professional but firm, explaining the relevant law and giving the HOA 14 days to reverse their decision and approve the wheelchair ramp. During those 2 weeks of waiting, life at home became increasingly difficult. Every time I needed to leave the house for a medical appointment or just to get some fresh air, it required planning and physical effort from Jennifer or whoever else was available to help. I felt like a burden, which I hated. Emma and Lucas tried to help too, but they were only 11 and 9 years old, and I didn't want them straining themselves trying to lift me. One afternoon, I was waiting in my wheelchair by the front door for Jennifer to bring the car around for a doctor's appointment when our neighbor from across the street, an older man named Harold, walked over. "David, I heard about the HOA giving you trouble about a ramp," Harold said, shaking his head. "That's just wrong. If you need any help, let me know. I'd be happy to sign a petition or talk to the board or whatever." His support meant more to me than he probably realized. I learned over the next few days that Harold wasn't alone. Several neighbors had heard about the situation, either through the community grapevine or because Jennifer had mentioned it to a few people, and most of them thought Patricia and the board were being unreasonable. A woman named Susan from 2 houses down even came by with a casserole and a handwritten note saying she supported us. But not everyone was supportive. I got an anonymous note in my mailbox a few days later that said, "HOA rules exist for a reason. Don't ruin our neighborhood because of your problem." I tried not to let it get to me, but it stung. April 13th arrived, marking the end of the 14-day deadline Robert had given the HOA. That afternoon, Robert called me with an update. "I received a response from Patricia Henderson," Robert said, and I could hear the frustration in his voice. "She's doubling down. Her letter says the board has consulted with the HOA's attorney, and they maintain that their architectural guidelines are legitimate and enforceable. She claims that approving your ramp would require them to approve all sorts of modifications that would harm the community." "That's ridiculous," I said. "It's a wheelchair ramp, not some crazy addition." "I agree, and so does the law, but Patricia and her board apparently want to do this the hard way, so here's what happens next. I'm going to file a complaint with HUD and simultaneously prepare a lawsuit. The HUD process can take a while, but the lawsuit will put more immediate pressure on them." "How long are we talking?" I asked, thinking about how much longer I could endure this situation. "Hard to say exactly. A few months, maybe longer. These things don't move quickly. But in the meantime, there is something we can do. We can ask the court for a preliminary injunction, which is basically a court order requiring the HOA to allow you to install the ramp while the case is pending. Given the circumstances and the strength of your case, I think we have a good chance of getting that." Robert filed the lawsuit in the United States District Court for the Northern District of Georgia on April 17th. The complaint was a dense legal document, but the core of it was straightforward. It alleged that the Meadowbrook Estates HOA had violated the Fair Housing Act by denying me a reasonable accommodation for my disability, and it asked the court for several things, including an injunction requiring the HOA to permit the ramp, compensatory damages for the harm we'd suffered, and attorney's fees. The motion for a preliminary injunction was filed the same day, and Robert requested an expedited hearing given the nature of the case and my ongoing inability to access my home safely and independently. The lawsuit had to be served on the HOA, which meant a process server actually had to hand the legal documents to Patricia Henderson or another board member. According to Robert, this happened on April 20th. Patricia reportedly was not happy based on the process server's description of the encounter. 2 days later, my phone rang from a number I didn't recognize. Against my better judgment, I answered. "Mr. Carmichael, this is Patricia Henderson." Her voice was tight with barely controlled anger. "I want you to know that you have now cost this HOA thousands of dollars in legal fees. We have done nothing wrong, and yet you've decided to sue us." "Patricia, I just want to install a wheelchair ramp so I can enter my own house," I said, trying to keep my voice steady. "This didn't have to become a legal matter." "You are trying to force us to violate our own governing documents," she snapped. "These rules were put in place to protect everyone's investment. If we let you do whatever you want, then everyone will want exceptions." "It's not whatever I want. It's a medically necessary accommodation for a disability. That's protected by federal law." "We'll see what the judge says," Patricia said coldly. "Don't expect this community to welcome you after you've dragged us through court." She hung up. I sat there feeling a mix of anger and sadness. I hadn't wanted any of this. I just wanted to live my life. The hearing for the preliminary injunction was scheduled for May 4th. Robert prepared extensively, gathering affidavits from my doctors, photos of our front entrance and the difficulties I faced accessing it, and detailed information about the proposed ramp and how it would meet all building codes and safety requirements while having minimal visual impact. The night before the hearing, I barely slept. Jennifer and I talked late into the night about what might happen. She held my hand and reminded me that we were doing the right thing, that this wasn't just about us but about standing up for basic rights. The courthouse was, ironically, extremely accessible. We arrived early, and Robert met us in the hallway outside the courtroom. He looked confident in his dark suit and carried a leather briefcase stuffed with documents. "Remember, this is just the preliminary injunction hearing," Robert reminded me. "We're asking the judge to require them to let you build the ramp while the full case proceeds. But the arguments today will preview a lot of what the full trial would look like." Patricia Henderson arrived with the HOA's attorney, a severe-looking woman in her 60s named Margaret Blackwell. Patricia wore a navy blue dress and pearls, and she looked at me with undisguised hostility. Two other HOA board members were with her, a man named Steve and a woman named Carol, both looking uncomfortable. The courtroom itself was impressive, with high ceilings, wood paneling, and the seal of the federal court on the wall behind the judge's bench. Judge Marilyn Foster presided, a woman in her early 50s with a reputation, according to Robert, for being fair-minded and knowledgeable about civil rights law. "Good morning," Judge Foster said as she took her seat. "We're here on the plaintiff's motion for a preliminary injunction in Carmichael versus Meadowbrook Estates Homeowners Association. Counsel, I've read your briefs. Mr. Chen, this is your motion, so please proceed." Robert stood and approached the podium. He spoke clearly and persuasively, explaining my situation, the medical necessity of the wheelchair ramp, and the HOA's unjustified refusal to approve it. He argued that I was suffering irreparable harm every day I couldn't safely and independently access my home, and that the law was clearly on my side. "Your Honor, the Fair Housing Act is unambiguous," Robert said. "Housing providers, including homeowners associations, must make reasonable accommodations for people with disabilities, unless doing so would impose an undue burden or fundamentally alter the nature of their operations. A wheelchair ramp for a person who uses a wheelchair is the epitome of a reasonable accommodation. The defendant HOA has offered no legitimate justification for its denial, only aesthetic concerns that the law does not permit them to prioritize over my client's civil rights." Judge Foster asked several pointed questions about the specifics of the proposed ramp, the HOA's rules, and what alternatives had been considered. Robert had answers ready for all of them. Then it was Margaret Blackwell's turn. She argued that the HOA had legitimate architectural guidelines designed to preserve property values and community aesthetics, and that these guidelines were applied uniformly to all residents. She claimed that granting an exception for my ramp would open the floodgates to other exception requests that would undermine the entire purpose of having an HOA. "Your Honor, if we must approve every modification a homeowner wants simply because they claim some hardship, then our governing documents become meaningless," Blackwell argued. "The plaintiff has alternatives available to him, including a rear entrance ramp that would be far less visible and would not violate our guidelines." Judge Foster did not look impressed. "Counsel, are you seriously arguing that the Fair Housing Act doesn't apply to your client's architectural guidelines?" "I'm arguing that our guidelines are reasonable, and that the plaintiff has alternatives that would be less intrusive to the community's aesthetic standards." "But the alternative you're suggesting would require the plaintiff to always enter his home through his garage. That's not equivalent access to the front entrance that every other resident enjoys, is it?" Blackwell fumbled her answer, and I could see Robert trying to suppress a small smile. The hearing lasted about 90 minutes. At the end, Judge Foster said she would issue a written ruling within a week. Those next few days crawled by. I tried to distract myself with work, taking video conferences from home and coding from my wheelchair in our converted downstairs office. But my mind kept returning to the hearing and wondering what the judge would decide. The ruling came on May 9th. Robert called me at 3 in the afternoon, and I could hear the satisfaction in his voice before he even said the words. "We won," Robert announced. "Judge Foster granted the preliminary injunction. She's ordering the HOA to immediately approve your wheelchair ramp and to not interfere with its installation. Her written opinion is 17 pages, and it's very favorable to us. She basically says the HOA's position is legally indefensible and that you're likely to succeed on the merits of your full claim." I felt a wave of relief so intense that tears came to my eyes. Jennifer, who was sitting next to me, heard Robert's words and wrapped her arms around me. "What happens now?" I asked when I could speak again. "Now you can call your contractor and schedule the installation. The court order is effective immediately. If the HOA tries to interfere, they'll be in contempt of court, which they definitely don't want." I called Marcus that same day. He was thrilled to hear the news and said he could start the installation within a week. We scheduled it for May 16th. The week leading up to the installation, I kept waiting for Patricia or the HOA to try something, but there was silence. I later learned from Susan, my supportive neighbor, that there had been an emergency HOA board meeting where Margaret Blackwell, the HOA's attorney, had apparently told them in no uncertain terms that they had lost this battle and needed to comply with the court order or face serious consequences. Marcus and his crew arrived at 8 in the morning on May 16th with a truck full of aluminum ramp sections, handrails, and tools. I watched from inside as they worked, methodically assembling the ramp along the side of our front steps. The weather was perfect, sunny and warm, and neighbors occasionally walked by to watch the progress. Harold came over and chatted with Marcus for a few minutes, giving him an encouraging thumbs up. The installation took 2 full days. By the evening of May 17th, my wheelchair ramp was complete. It was everything Marcus had promised: sturdy, safe, with a gentle slope and solid handrails. The aluminum was painted a light gray that complemented our house perfectly. It looked professional and, honestly, not that visually intrusive at all. Patricia's dire warnings about it destroying the neighborhood's aesthetics seemed even more absurd now that I could see the actual finished product. That evening, after Marcus and his crew had packed up and left, I rolled myself out the front door and down the ramp for the first time. It felt incredible. Such a simple thing, being able to leave my house independently, but it meant the world to me. Jennifer and the kids came outside, and we took a family photo on the front porch with the ramp visible in the background. Emma and Lucas were grinning, and Jennifer had tears in her eyes. "We did it, Dad," Lucas said, hugging me. "Yeah, we did, buddy," I replied, but the legal case wasn't over. The preliminary injunction had given me the ramp, but the underlying lawsuit was still pending. Robert explained that we now needed to either go to trial or negotiate a settlement. "The HOA knows they've lost," Robert said during a phone call in late May. "Judge Foster's ruling was devastating to their position. Their attorney has reached out to discuss settlement. They want to avoid a trial and a potentially larger judgment against them." "What are they offering?" I asked. "Nothing yet. This is just preliminary discussion. But I want your input on what you want to achieve here. Obviously, you have your ramp now, which was the primary goal. But you've also been through significant stress and expense because of their illegal denial, and you're entitled to compensation for that. Plus, we want to recover my attorney's fees so you don't have to pay for any of this." I thought about it. "I want them to understand they did something wrong. I want to make sure they don't do this to someone else, and honestly, yes, I want to be compensated for everything we went through." "All reasonable goals," Robert said. Let me negotiate with them and see what we can work out. The settlement negotiations took place over the next month. Robert kept me updated on the back and forth. Initially, the HOA offered $2,500 to settle the entire case, which Robert rejected immediately as insultingly low. He countered with a demand for $15,000 in damages plus his attorney's fees. Margaret Blackwell, the HOA's lawyer, pushed back hard. There were several rounds of offers and counteroffers. The HOA was clearly reluctant to pay anything substantial, but they were also worried about going to trial and potentially losing even bigger. In mid-June, Robert called with an update. They've offered $7,500 in damages, plus they'll agree to pay my attorney's fees, which I'm billing at $8,200 for the work I've done so far. That's a total of $15,700. That's more than your original counteroffer, I noted. It is because the attorney's fees are separate from the damages. The damages are compensation to you for the harm you suffered. The attorney's fees are to reimburse you for the cost of having to hire me to enforce your rights. The Fair Housing Act allows you to recover both. But you said you were working on contingency, I said, confused. I was, which means you wouldn't have to pay me out of pocket. But under the Fair Housing Act, when you win, the defendant has to pay your attorney's fees directly. So you get to keep all of the damages award, and the HOA pays my fees separately. It's designed to make it financially feasible for people to stand up for their rights without going broke hiring lawyers. So if I accept this settlement, I get $7,500 and don't owe you anything. Correct. And the HOA pays me $8,200 on top of that, for a total payout from them of $15,700. It seemed like a reasonable resolution. I was never interested in getting rich off this lawsuit. I just wanted my ramp and wanted the HOA to be held accountable for what they'd done. Let's counter at $9,000 for me and $8,200 for you, I suggested. Total of $17,200. If they agree, we settle. If not, we can consider their offer. Robert made the counter-proposal. 2 days later, Blackwell responded. The HOA would agree to $8,900 in damages to me plus the $8,200 in attorney's fees. Total payout, $17,100, just $100 less than my counter. I think you should take it, Robert advised. It's a solid settlement, and it avoids the uncertainty and delay of going to trial. Plus, it sends a clear message to the HOA that what they did was wrong and costly. I agreed. The settlement was finalized in writing over the next week. The terms included not just the money, but also a requirement that the HOA revise its policies and procedures for handling accommodation, requests from residents with disabilities, and that the board members complete training on Fair Housing Act compliance. Robert insisted on those provisions to help prevent future incidents. The settlement agreement was executed on June 27th. The HOA had 30 days to pay the settlement amount. The money arrived via check on July 18th, 21 days after the agreement was signed. I received a check for $8,900 made out to me, and Robert received his check for $8,200 from the HOA's insurance company, which apparently was covering the settlement after initially denying the claim. That $8,900 didn't change my life financially, but it represented something important. It was an acknowledgement that what the HOA had done was wrong and that there were consequences for violating someone's civil rights. Patricia Henderson resigned as HOA president in August. I heard through the neighborhood grapevine that she had been facing pressure from other board members and residents who were unhappy with how she'd handled the situation and the financial cost to the HOA. Steve, one of the board members who had been at the court hearing, took over as president. He sent me a brief email apologizing for what had happened and pledging to do better. I responded politely, accepting his apology. I didn't want to be at war with my HOA forever. I just wanted to live my life. As summer turned to fall, life gradually found a new normal. My physical therapy continued, and I actually regained some mobility in my legs, though I still relied on the wheelchair for most activities. The ramp became just a normal part of our house, something the neighbors stopped noticing after a while. Emma and Lucas went back to school. Jennifer returned to her part-time job as a graphic designer, and I continued working remotely. One afternoon in October, I was outside on my front porch reading a book when a car pulled up in front of our house. A woman in her 30s using crutches got out and slowly made her way up our driveway. I recognized her as someone I'd seen around the neighborhood but had never formally met. "Hi, I'm Rachel," she said, introducing herself. "I live over on Birch Street. I hope this isn't weird, but I wanted to thank you." "Thank me for what?" I asked, confused. "I have multiple sclerosis," Rachel explained. "It comes and goes, but when it's bad, I have trouble with mobility. I've been thinking about getting a ramp installed at my house for when I'm having a flare-up, but I was afraid the HOA would give me the same runaround they gave you. When I heard about your case and how you fought back and won, it gave me courage. I submitted my accommodation request last month, and the new board approved it in 3 days. I think they learned their lesson." I felt a swell of emotion. "That's wonderful, Rachel. I'm so glad it helped. Your situation made a difference not just for you, but for others like me in this community. So thank you for not backing down." After Rachel left, I sat on my porch for a long time, thinking about everything that had happened over the past year. The accident, the long recovery, the fight with the HOA, the lawsuit, and finally the settlement. It had been exhausting and infuriating and sometimes scary, but in the end it had been worth it. The wheelchair ramp was still there, exactly where it belonged, allowing me to come and go from my house with independence and dignity. And now it had helped someone else too. That evening, Jennifer and I sat on the couch after the kids had gone to bed. She rested her head on my shoulder, and we talked about everything we'd been through. "You know what the craziest part is," I said. "All of this, the lawsuit, the $17,000, the judge's ruling, all of it could have been avoided if Patricia had just approved the ramp in the first place. Some people are so attached to rules and control that they can't see past them to basic human decency," Jennifer replied. "But you changed that. You forced them to see that disability rights aren't negotiable." I kissed the top of her head. "We changed it. I couldn't have done this without you." The following spring, the Meadowbrook Estates HOA held its annual meeting. It was the first one I'd attended since moving in. Steve, the new president, gave a presentation about the previous year and the changes the board was implementing. He specifically mentioned new procedures for handling accommodation requests and the Fair Housing Act training all board members had completed. "We learned some hard lessons," Steve said to the assembled residents, "and we're committed to being a more inclusive and understanding community going forward." During the open comment period, Harold, my neighbor from across the street, stood up and said, "I just want to say that David Carmichael showed a lot of courage standing up for his rights, and I'm proud to live in a neighborhood with him." Several people applauded. I felt my face get hot with embarrassment, but I also felt grateful. After the meeting ended, a handful of residents came up to talk to me. Some apologized for not being more supportive during the conflict. Others shared their own stories of family members with disabilities. One elderly man told me about his grandson, who had cerebral palsy, and how important accessibility was for his quality of life. As Jennifer and I drove home that night, I realized that something had fundamentally shifted. What had started as a painful conflict had somehow brought about positive change, not just for me, but for the entire community's understanding of disability rights. The next few months were quiet and peaceful. I focused on my work, my family, and my continued physical therapy. The ramp became invisible in the best possible way, just a functional part of our home that allowed me to live my life. In August, nearly a year after the settlement, I received an email from Robert Chen. He was writing to tell me about another case he'd taken on, this time involving a deaf couple whose HOA was refusing to let them install a visual doorbell system. Robert said my case had inspired them to fight back, and he wanted to keep me updated. I responded, wishing him luck and offering to serve as a witness or provide a statement if it would help. The case settled favorably 2 months later without going to trial. The HOA in that case had apparently researched similar cases, found mine, and decided not to repeat Meadowbrook Estates' mistake. As I write this now, it's been 2 years since I first installed my wheelchair ramp. I still use it every day. I still use my wheelchair, though I've regained enough strength that I can walk short distances with a cane. The physical recovery has been slow and incomplete, but I've adapted and found ways to live a full life. The ramp is no longer a point of controversy or even conversation. It's just there, a simple aluminum structure that allows me to access my home, exactly as it should be. Patricia Henderson moved out of Meadowbrook Estates about a year after the settlement. I heard she relocated to a condo in Buckhead. I harbor no ill will toward her. I think she genuinely believed she was protecting the community, but she was wrong, and she learned an expensive lesson about federal civil rights law. The money from the settlement went into savings. We used some of it to make other accessibility improvements around our house, things that weren't legally necessary but made life easier. A roll-in shower in the master bathroom, wider doorways. Better lighting. The rest we saved for the kids' college funds. Looking back on everything, I'm glad we fought. It would have been easier to give up, to accept the HOA's denial and find some workaround, but that would have been wrong. Disability rights matter. Accessibility matters. And sometimes you have to stand up and fight for what's right, even when it's hard and scary and uncertain. The Fair Housing Act exists for a reason. It protects people like me from discrimination, from being treated as second-class citizens in our own communities. Without that law and without attorneys like Robert Chen who know how to use it, I might still be unable to safely access my own front door. Emma is 13 now and Lucas is 11. They both remember the fight over the ramp, and we've talked about it as a family. I've tried to teach them that standing up for yourself and others is important, that laws exist to protect people's rights, and that sometimes doing the right thing requires courage and persistence. Last month, Lucas had to do a school project about someone who inspired him. He chose me, and he titled his presentation "How My Dad Fought for His Rights." He included photos of the ramp, copies of news articles about the case that had been published in local papers, and his own memories of that difficult time. Watching him present it to his class via video call, I felt proud not just of him but of what our family had gone through together. Jennifer still works as a graphic designer, now full-time. She's incredibly talented, and her business has grown steadily. She attributes some of her success to the confidence she gained from supporting me through the legal battle. "I learned I was tougher than I thought," she told me once. Harold still lives across the street. We've become good friends over the past 2 years. He often invites me over to watch football games, and he built a ramp to his own front porch, even though he doesn't need one, just to make his house more accessible when I visit. That gesture meant more to me than he probably knows. Susan, the neighbor who brought us a casserole, has become one of Jennifer's closest friends. They get together for coffee regularly, and Susan has been a wonderful support system for our family. Rachel, the woman with MS who thanked me, got her ramp installed, and we've become friends as well. We sometimes commiserate about the challenges of living with mobility issues, and we've talked about maybe starting a local disability advocacy group to help others navigate situations like what we both faced. The Meadowbrook Estates HOA under Steve's leadership has been reasonable and responsive. They approved another accessibility request last year, this time for a resident who needed a stair lift installed on their front porch. The approval came within days, without any pushback. The community is learning and changing, which was one of my goals all along. I still see Margaret Blackwell's name occasionally in legal notices in the local paper. She continues to represent HOAs, though I wonder if she advises them differently now after losing so decisively in my case. Judge Marilyn Foster was appointed to the 11th Circuit Court of Appeals last year, a well-deserved promotion. Her ruling in my case was cited in several subsequent Fair Housing Act decisions, creating precedent that helps other people with disabilities fight similar battles. Robert Chen's practice has grown significantly. He now has 3 associates working with him, and his firm has become known as one of the best disability rights practices in Georgia. We stay in touch, exchanging occasional emails and meeting for lunch once or twice a year. He tells me that my case remains one of his favorites because of how clear-cut it was, and how it led to real, positive change. The $8,900 settlement represented about 5 months of stress, dozens of hours of work, and the principle that my rights as a person with a disability matter. It wasn't enough to compensate for everything we went through emotionally, but it was accountability. It was the HOA admitting, through their pocketbook, that they had violated federal law and caused harm. More importantly than the money, though, was the change in policy and attitude. The required Fair Housing Act training for board members, the new procedures for accommodation requests, and the general awareness in the community about disability rights. These things have lasting value beyond any dollar amount. I sometimes think about that anonymous note I received early in the conflict, the one that said I was ruining the neighborhood. I wonder who wrote it and whether they still feel that way. The neighborhood hasn't been ruined. Property values haven't collapsed. The apocalyptic predictions about a flood of modification requests never materialized. Life just went on, except now a few more people can access their homes safely and independently. That's what this whole fight was really about. Not about being difficult or causing trouble or suing for money. It was about the basic principle that people with disabilities deserve equal access to their homes and communities. It was about refusing to accept discrimination, even when it came wrapped in the language of aesthetic guidelines and property values. The law was on my side. Justice was on my side. And in the end, that mattered. My wheelchair ramp stands as a quiet testament to all of that. It's aluminum and gray paint and non-slip treads. It's also dignity and independence and civil rights. It's a reminder that sometimes you have to fight for what's right, and that when you do, you can win. Every time I roll down that ramp, leaving my house to go to work or visit friends or just enjoy a beautiful day, I'm grateful. Grateful for Jennifer's support, for my kids' resilience, for Harold and Susan and other neighbors who stood by us, for Robert Chen's expertise and dedication, for Judge Foster's wisdom, and for the Fair Housing Act that made it all possible. The fight was hard, but it was worth it. And if I had to do it all over again, I would make the same choices. Because some things are worth fighting for, and basic human dignity is at the top of that list. Today is a beautiful Saturday in March. The dogwoods are starting to bloom, and there's a warm breeze blowing through our neighborhood. I'm sitting on my front porch, the same porch that was once inaccessible to me, watching Emma and Lucas play basketball in the driveway. Jennifer is inside making lunch, and Harold just waved from across the street where he's mowing his lawn. Life is good, Not perfect, but good. The challenges of living with a disability haven't disappeared, but I face them from a place of strength, knowing that I stood up for myself and won. The ramp is still here, solid and functional, doing exactly what it was always meant to do, giving me access to my own home. And that, in the end, is all I ever wanted.